Welcome to the Landlord Advocate.
Hey everyone, welcome into an all-new episode of the Landlord Advocate with Matthew Paletz, the CEO of Paletz Law. I am your host, Mike Leon. Matt's joining me today to talk about how to enforce your lease without stepping into legal risk, especially when it comes to discrimination claims, emotional support animals, and inconsistent enforcement. Another topic we'll be touching on today is something that's keeping landlords up at night, and Matt's going to explain if it is, and that's fair housing compliance. If you manage multiple properties or teams, this conversation is going to help you recognize these issues so you can be better prepared to deal with them. Matthew, it's good to see you as always. Let me ask you at the onset here, why is fair housing such a common legal trap for landlords and property managers?
Well, thanks for having me, Mike. Yeah, that intro is quite the mouthful. And it's probably indicative of the fact of just how convoluted fair housing claims can get. Um, and it really is something that landlords and property owners have to take into consideration on a daily basis. And if they don't, it's going to be a major problem for them down the road. It's the perfect storm when you're trying to navigate between offering, just the most pleasant experience you can as a property owner and trying to be customer service oriented on behalf of your tenants, but also be mindful of the fact that tenants are going to make certain demands and certain accommodation requests. That's more of the legal term for fair housing disputes. And many of them are legitimate, but there's also a disproportionate amount of them that are bogus. And you really need to be mindful. You'd have to have your staff engaged, and you got to have a heavy hitter lawyer in your back pocket that understands the stuff. And of course, that's what we do at Paletz Law.
Yeah. Well, a mouthful I'm equipped to do, so that's why I'm hosting here. But I wanted to ask you, let's talk a little bit about, a new administration comes in. Obviously, there's new appointees across these federal agencies. And I wanted to ask you about one in specific with HUD. What are some of the changes going on right now with HUD that you're seeing, especially when it comes to the state of Michigan?
Yeah, there's a ton of changes at HUD going on right now. The HUD secretary, at the end of last year, issued a whole bunch of memoranda that really was quite unprecedented. Although we're waiting to see what the actual impact of this is going to be, nonetheless, for them to just outwardly address some of these issues was quite unprecedented, as I said. One of the things they talked about was disparate impact enforcement. Now, I'm really going to try hard not to bore your audience here. Because this stuff gets pretty wonky, I guess is the best way to say it. But disparate impact is a concept in fair housing circles that basically said that, look, if you have a policy on its face that's neutrally written, in other words, there's nothing that you could say has an intent to discriminate overtly, but yet the impact of it had a disparate or disproportional impact on a certain group of individuals that have fair housing protections, then you could still find fair housing liability into that. And again, that's a really difficult concept, not only to understand legally, but just it has a hard time that doesn't make much sense in the real world, right? Because you're like, hey, I'm operating my property. I'm not trying to discriminate against someone, but yet why are you finding fair housing discrimination liability against me? If you want, I can give you an example of what that would be, Mike. Let's say you had a policy that said, hey, you need to have full-time employment in order to be an applicant here. Makes perfect sense, right? You want to make sure that some people can actually pay their rent on time. However, let's say that you have a disability that prevents you from being full-time employed. So even though you didn't intend to discriminate someone against having a disability, that policy could be inferred as potentially discriminatory against them. And again, I've probably lost 95% of our listeners already, or our viewers. But it does. It's the point is it gets very intricate and it gets convoluted. And so getting back to the current administration, they said, hey, we're going to take a pause on this. We're looking at maybe rescinding some of this. Again, these are memorandum. They're not law. Okay. So it just, what it does is it creates a lot of confusion. So are they going to enforce this? Are they not? And then the states are sort of looking at the federal government for direction. And so there creates confusion there. Well, what is the federal government going to say? How should we enforce this? And so again, it creates a lot of confusion, a lot of headaches for then landlords. And that's why I guess I would say I'm the human excedrin to try and prevent them from having to think too hard or bash their head against the wall on some of this.
Yeah.
There was a lot of other stuff that went on, and I know I'm droning on, but like criminal background checks, for example. At one point, look, you are always allowed to do criminal background checks as a landlord to determine, rightfully so, right, who is going to be renting in your property. And so there were movements afoot in the 2010s and the 2000s about saying we want to curtail some of those criminal background checks. Well, now the HUD secretary said, no, we want to reinstate them. Again, these are guidance only, and that gets confusing. So there's that. And then, of course, there's what they wanted to do about service and emotional support animals, which I'm sure we'll talk about later. We could probably talk, for the next 10 years on that. They also, talked about that. And so there's all the bottom line is they just was a blizzard of a lot of these things that has now created a lot of confusion. Personally, I think it's going in the right direction. The less enforcement on this stuff is better because it's ripe with abuse in the system. And so at least they're tackling the issue. I guess that's the silver lining there.
Right. Well, you're the lawyer. That's why you're here to breeze through the confusion for us, Matt. So, but let me ask you, because it funnels into a follow-up beautifully, which is how have you seen when this happens, when these broader legislative shifts happen, whether it be at the federal or state level, like how is it changing the way landlords need to start thinking about compliance? You mentioned the 2010s, they're thinking about it one way, and then now they're thinking about it in a different way. Like, how does it change?
Yeah, it's very fluid. And it's not just the federal government, it's not just the state government, but even local municipalities. Local cities will enact their own fair housing regulations. And so as a housing provider, you need to know where you're operating. And I know that sounds ridiculously simple, but it's so true. You need to know what your current political environment is and what the individual cities are also trying to offer as far as tenant protections. And again, look, a lot of these are, I'm sympathetic to the reason behind them. A lot of these are well-intentioned, but, there's an old phrase, right? The road to hell is paved with good intentions. And I say that to my clients all the time. And that really is what really muddies the waters here, is that although maybe some of these are well-intentioned, they just go too far. And so it is confusing. And it also, there are a lot of legal landmines that, property owners can step in. And if you don't have an attorney that is really well versed in in this area, and understanding the federal, the state, and the local levels, you're going to be doing yourself a disservice. And you are playing Russian roulette. That's just what's going to happen. It's never in the best interest of property owners to discriminate. I know that gets popular online, and a lot of things that paint landlords in a negative light are popular and easy and intellectual lazy. And as you can see, I get fired up about it. It's just landlords are not, look, my clients love me, but they don't want to have to use my services, right?
Right.
Because it's a cost. And so landlords have, what is their monetary incentive to discriminate? There isn't one, right? So, look, maybe during the 60s, and that's, before yours and my time, there were a lot of things that were going on and a lot of upheaval, but, we're in 2026, right? So I think a lot more landlords are more savvy to understand that, hey, this isn't in their best interest, and they're going to do everything they can to just provide that harmonious environment for their tenants. And starting out of the gate, acrimoniously trying to discriminate against people is just not in their matrix, if I can adequately say it that way.
Yeah. Yeah, it's going to affect their bottom line. Let me ask you, you mentioned emotional support animals. So I'm going to give you can't talk about it for an hour. It's a podcast, but how do emotional support animal requests kind of factor into these fair housing risks?
And I don't mean to belittle emotional support animals, but this is the topic that I get asked as a fair housing expert. I get asked about this pretty much. It just sucks all the oxygen out of the room. Because it is so pervasive and there's so many bogus discrimination claims. And that's the problem. It really does anytime you have a bogus emotional support animal claim, it undermines an otherwise legitimate need. I've seen people, I know people personally who have, struggle with anxiety, and the power of having an animal to help quell that is very, that can't be understated. But when you use it as an opportunity to, let's say, I don't want to pay a pet fee, so I'm going to declare my, 140-pound cane corso as an emotional support animal, that's where you lose me. And I've done so many of these cases. I mean, I long for the day of the garden variety pit bull. Those were like the first ones that came through. And no disrespect to anybody who has a pit bull. One of my best friends growing up had one. It was the sweetest dog ever. But the statistics don't lie, right? But pit bulls, I wish I dealt with those cases these days. I've dealt with a boa constrictor. I've dealt with not one chicken, but an entire chicken coop. I've dealt with multiple cats. It's like, well, it's like this cat helps me with this and this cat helps me with that. I mean, at some point, it just becomes so ludicrous. And that's the point. But if your viewership takes one lesson away from me today on this, it's no matter how ridiculously absurd an emotional support animal request is, you never want to outright deny it. Just ask them to submit the request in writing. And even if it's a emotional support animal llama, okay, or an alpaca or something,
Right.
even if it's a elephant or a horse, whatever, you could enter, whatever animal you want. I've seen baby kangaroos before around the country. Kid you not. I kid you not. But no matter how absurd it is, do not outright deny it. Just ask for them to submit the request in writing, and then we'd have to look at it. That's how you got to deal with this. And yes, I could talk for months on this, and again, everybody would leave, and it'd just be me and you, and I'd probably need my own emotional support animal.
Listen, unless you're Jake the Snake Roberts, you don't need an emotional support animal for a boa constrictor request.
You're dating us now when you say that, right? How many people remember Jake the Snake Roberts?
Exactly. Well, listen, we're blending the wrestling audience with the legal audience, but
Right.
let me ask you. Let's go to the landlord audience for a second. What steps would you recommend to landlords out there? You mentioned something about documenting the communication, but like, what other steps should they take to document the communication and these decisions properly?
Yeah, I have a friend of mine that says, look, if it's not in writing, it didn't happen, right? And so that's really important. I always, if we want to use other references like Jerry Maguire, I always say this to my clients, like, help me help you, okay? What can you do to put things in writing, document things? One of the biggest lightning rods for any fair housing advocate that is going to go after a landlord is, do you have a written fair housing policy? That's going to be the number one question. And it's just one of those things from a compliance perspective, you need to make sure you have. And of course, shameless plug at Paletz Law, we draft those all the time and routinely for our clients. Plus, then how do you deal with the accommodation request? Do you have a system in place? Do you have forms? These are all things that just, show that you're a professional housing operator and that you know what you're doing. And so that when someone who's coming in and trying to, catch you in something, their first question is going to be, hey, what did you have as far as compliance? And you can just take the wind out of their sails from that perspective.
Man, let me ask you as well, like what role, I should say, does training kind of play as well in maybe staying ahead of a potential discrimination claim?
My training is critical. We conduct trainings all the time, whether it be on webinars or in person. It's so vitally important that corporate gets their field team to understand that, look, even though they don't mean to, they can be bound by things that they say. And I'll give you an example of this. There was once a tenant who was in an elderly community and was a bit arthritic. And so they had asked the maintenance man just an innocuous question. Hey, do you think maybe you might be able to, instead of having a turnkey lock, because they were having problems with the key, to change it to a keypad? And the maintenance man, didn't mean anything by it. It was very honest. It was like, no, we've never done that before. Well, $10,000 later, after they got fined for it, they did. And the bottom line is that, again, there was no ill intent on behalf of the maintenance person. He was just being honest. The point is, when I'm doing these trainings, is to get the field team to understand that, hey, what you say can be bound, even if there wasn't a formal request by the tenant. Nonetheless, it was interpreted by that because the scales are very highly tipped towards a tenant. And so when I do these lectures, or even to your viewership, I'm like, look, you don't have to be an expert in this. That's for us to do. But you just need to be aware, have an awareness, so that when somebody's asked like that, don't make an answer, just have them request it in writing. And that's really important. That's where the training comes in. Say, hey, I remember, talking to this lawyer about this, and they said, oh, wait a minute, maybe I should just pause for a second and request it in writing. And that's the bottom line. So that's my answer to your question. It's really important. And we conduct it all the time at Paletz Law. As I said, either virtually or in person.
Well, that's great to hear. And Matt, as we kind of wrap on this episode, a final piece of advice for the landlord out there, and maybe they're feeling a little stuck between, protecting the property versus avoiding the legal blowback. How would you advise them going forward?
Yeah, I call this kind of compliance stuff as like the 21st century version of ambulance chasing. You have testers, and you have all these additional tenant rights groups. And again, landlords, they're not incentivized to discriminate, right? But they're a deeper pocket, and so they're a target. I would just say that just have some awareness. You don't have to be paranoid. You don't have to say, oh, the deck is fully stacked against us. A lot of times what helps with that is having a lawyer in your corner, okay, that knows what they're doing. And that's, again, what I try to explain to my clients is like, look, you don't need to panic. Just make sure you got my number on speed dial. Another dated reference, I guess. But,
Yep.
Just give us a call, send us an email. Let us know, hey, look, this inquiry was made. I'm not exactly sure what to do with it. Before I respond, can you give me some advice? And that's what I'm really trying to impart on the viewers today. Just before you act, call the lawyer. Let the lawyer just get them involved early. Early is better than later.
Depends on what position in that speed dial. We're dating ourselves here, Matt. Thank you again for the time.
Number one.
Number one. Thank you again for the time and the insights, Matt. I appreciate it.
All right. Thanks, Mike.
If your lease enforcement strategy isn't legally compliant, your whole business is vulnerable, folks. So do me a favor. If you want more tools, you want more templates, you want a legal partnership, you're going to visit palettzlaw.com. Thank you again for listening to this episode of The Landlord Advocate. But one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.